The South African Land Reform Commission is proposing an integrated approach to help deal with family disputes, especially those involving children. It says an approach based on mediation and arbitration could be a lot more effective than court processes. The discussion is open for public comment till Friday. We are joined by the WC Social Development Standing Committee Chairperson, Gillian Bosman, to discuss this. A very good morning to you. Talk us through it, what it all means. How's it going to work?
Good morning, Jane. Well, what is being proposed is a form of alternative dispute resolution, which will significantly reduce the amount of court time that parents face post-divorce or while deciding custody cases. We know from the latest Department of Social Development white paper that non-marital childbearing households is quite prevalent in South Africa. Approximately 58% of all births in the country is to non-marital households. And we also know that the majority of divorces in 2017, that's approximately 55%, involve children. And in order for disputes to be settled around who has custody and what type of custody agreements are in place, it is important that an alternative mechanism to the quite litigious court process is in place. In the Western Cape, for instance, the Department of Social Development has been using alternative dispute resolution mechanisms, and they've called it facilitation, to capacitate families to be able to make those decisions, especially families who can't afford the lengthy court process. And what it means, it's a form of parenting coordination, and it's an internationally recognized practice that's non-adversal, and that takes the best interest of the child into consideration, because we know that the quite complicated and sometimes quite technical legal processes is sometimes much more difficult on the development and the further development of children. So that's an approach that provision is made for it in the Children's Act, and what the Children's Act also allows for is for the MEC for Social Development in the respective province to make mechanisms available to offer that kind of facilitation services.
And what how the South African Law Commission is it? I mean, is it expediting the process? Is it making it a lot more amicable?
I think it is. I think some of the challenges in this case is that when a court orders for alternative dispute resolution, it really depends on how qualified the mediator is and how willing the parents are to abide by the agreements. We know that custody battles can sometimes be quite messy, and it's really how people come to the party and use the process. What we also have is we don't have a dedicated family court in South Africa, but we do have the Children's Court, a very few magistrates and high court justices that are able to sign off on these reviews. So I think what we need and what the discussion document calls for is for a specialized setup where there are qualified and capable social workers or dispute resolvers that are able to assist families, specifically families who can't afford the litigious court process.
And Gillian, will it help in the cases where the kids are estranged from one of the parents because the other parent is keeping them away?
I think one of the things that this process does, it gives an opportunity for the child to participate in the process as well. And what this process allows is for the child's voice to be included. And parenting coordination also allows social workers and specialists to look at the circumstances of the child and how the child's best interest is being served. I think what it does is it opens an opportunity for the parents as well to enter into a conversation instead of just talking through lawyers.
Gillian Bosman, good to talk to you. Thank you.